was a member of the board from 1995 to 2002. As she just told me, she meets the requirements for suspension of deportation, because she has extreme hardship. No, 7 years. She is the CEO of the Ideas Consultation and Coaching, where she does a lot of advising people and mentoring them about their immigration-related cases and employment empowerment more generally. I know that she's advised us in the immigration clinic on various issues. She also was a law professor. She also co-authored Immigration Law and Crimes. As I said, adjunct professor at American University, Washington College of Law. She's also the director of NLADA, Defending Immigrants Partnership, director of the AIC Legal Action Center, the founder of Centro Presente, Central American Asylum Seekers Legal and Pro Bono Programs, a member of the Federal Bar Association, elected to the American Immigration Law Association Board of Governors, and the recipient of many, many awards. And we are very happy and honored to have Judge Rosenberg. Thank you.
Thank you, everyone. I'm really so glad to be here. As I said earlier, it's a real treat to be able to be at this conference, and thank you so much for inviting me. I'm really honored to be asked to present a keynote speech. And this is great because I like standing up so I can move around a little bit. Do you all feel lulled into a soporific state now after lunch? Do you feel like you would benefit by standing up and doing a few jumping jacks or something like that? I mean, seriously, if you want to get up for a second and wave your hands or whatever, do it mentally, just so that, yeah, twist around in your seat or something, just so everybody's alert. All right, yeah, right, there you go. Okay. Good, okay, great. So, yeah, stay alive, guys. Stay alive. Okay, so I bet you don't know what I'm going to talk about, right? Guess what? It starts with the first two letters of the alphabet. Okay, so I have a lot to deliver on now because we kept promising I was going to talk about this one week when we got to the keynote presentation. But I did make some notes just so that I make sure that I don't overlook a few things. And I want to share with you, how much time do I have?
You have about an hour.
Oh, okay, great. That's plenty of time. That's plenty of time. All right, okay. So I want to share with you some of the things that you may or may not know about the actual case matter of AB, because it's kind of endemic to the world that we're operating in and fighting in and struggling in on behalf of our clients these days. This case, and actually it was an actual legal component of the case, this case was originally before an IJ in Charlotte, North Carolina, who has somewhat of a reputation for being an extremely irritating, difficult person to deal with. His name is Judge Couch, C-O-U-C-H. I don't mind naming judges. I know people are often so prudent about not doing that, but fortunately, I don't practice in immigration court anymore. So I understand why people sometimes hesitate to out their judges. But I want to tell you about this judge because this judge he's a repeat offender. And here's what happened in this case. This judge speaking of bias, has pretty openly acknowledged that he doesn't believe any of these DV claims for particular social groups are worth anything. He also doesn't believe that gang cases are worth anything. This is an issue that the idea of private actors being the persecutor is one that has just been something he's gone after for months and months and months. And fortunately, for those of us, I live in North Carolina now, so those of us who are within his district are also in the Fourth Circuit jurisdiction, and the Fourth Circuit jurisdiction has some of the best family PSG case decisions and some really great gang decisions. So it's apparently very frustrating for poor Judge Couch. So what happened in this case is that he was actually so out of control in issuing the decision in this case, AB, that when it went up to the Board of Immigration Appeals, the Board of Immigration Appeals reversed his adverse credibility finding, which is really rare, as you know. Then the Board of Immigration Appeals remanded the case back to him, basically rejecting all the positions that he had taken in denying the asylum claim. And it so happened that pending at the Fourth Circuit right at the same time was another case. I think it starts with V. I can't remember the name of it right now. But there was another case pending there which I think had been originated in his courtroom. And it was there on an issue of, it was charging a family as a social group. It was challenging that, and he had prevailed at the board, and so the respondent in that case filed a petition for review, and the only difference in that case having to do with family, that it had to do with a child custody situation, and possibly the respondent was not the custodial parent or something like that. It was not a real straightforward family case. So that case was pending. We didn't know this, of course. That case was pending up at the Fourth Circuit, and I think that he was waiting to be vindicated on his position. That's my opinion. I don't know that. So, that's totally my opinion. And so what happened is when the board remanded matter of AB, Ms. AB, the board remanded it with instructions to have her get her biometrics done and then set a hearing. And both circuit courts of appeal and the board, typically if they're going to grant a case, they won't grant it. They'll send it back to the IJ because asylum is discretionary. And so at the end of the day, there has to be a determination made whether or not asylum should be granted. Well, he sat on the case for 8 months and he didn't schedule a hearing. And he didn't notify the parties that he wasn't going to schedule a hearing, and time went on, and so finally I think his attorneys at the time inquired. They got the biometrics done, and we're waiting and waiting and waiting. And so some 11 months or something after the remand, this Fourth Circuit case came down, and in the Fourth Circuit case, they basically upheld Judge Couch, which was that this weird family group of a adopted child or a non-custodial child or something like that didn't constitute a cognizable family, particular social group. As soon as that came down, he then scheduled the hearing, but he didn't really hold a hearing. He issued a decision instead. And Judge Couch is prone to do this. He's done it in more than one case. He does it repeatedly. And complaints to EOIR and to the chief immigration judge just disappear into a black hole because a lot of people from the AILA chapter in that area have made these complaints. What he did is he filed, the board had remanded the case. He filed essentially another decision which was a response to the board, which he began writing as, now comes Judge Stewart, Immigration Judge Stewart Couch, like he was the petitioner, pleading with the board, restating his position and basically rejecting the decision the board had made, remanding the case to him, saying, I think I'm right, and look, here's this case in the Fourth Circuit, and blah, blah, blah. And so he did not even give the parties on either side an opportunity to brief this case. And it was totally in disobedience to what the board had ordered on its remand.
Look, didn't he certify it back to the board?
Yeah, he did certify it. He certified it back to the board, right. But he does it through these pleadings. And then, seriously, I've seen them. They're very strange. I don't know why he thinks he's supposed to be doing that. But he has this discourse with the board on his own constantly when he gets something remanded to him. So it was right at that point that Sessions intervened and took over certified the case and basically kind of swooped it out of the board's hands. And thankfully, actually, DHS actually filed a motion asking before the Attorney General would certify it to please let the board render a decision and let it run its normal course. Because the regs, a judge can't issue a second decision after he's already decided the case once and it's gone up and been sent back to him. He can only issue a decision after holding a new hearing, which he had refused to do. So the Attorney General basically rejected the DHS motion to stop the proceedings on certification. But it did, thankfully, say that Judge Couch was out of order, that it wasn't appropriate, that he didn't really have any, it's not really standing, but technically that he didn't have the authority to do what he had done, and so on. However, Sessions wanted to go ahead and decide the case. So as you know, you've seen what came out. So I just think that's really important. And the reason I say this again, going back to what I was talking about earlier this morning, is our group of judges, our gang of 14, as we call ourselves, we filed an amicus brief, and of course we have this unique perspective. We had, people who had actually literally retired within 4 to 5 months of this matter getting certified, and so they could talk about everything that was going on at EOIR and so on, and we had judges with long periods of service and very recent retirement, and we were really in a position to say, this is not the way we do things, we shouldn't do this, and that there were serious questions about the propriety of waiting for 8 months or waiting. Yeah, thank you. Actually, I'm just going to that's okay. About the propriety of waiting for this Fourth Circuit decision to come out in hopes that he could use it and cite it as authority to beat his principle in. So we wrote on that, and there were a lot of really other wonderful amicus briefs that were filed when this went to Sessions from all over, from the Harvard Clinic, from the group of professors called IMPROF, which is a kind of online listserv group of immigration law professors. A brief was filed. Then CGRS, the Center for Gender and Refugee Studies, filed a brief. There were just excellent briefs, and we had a great, wonderful law firms and writers doing a lot of these briefs for us. So that was really a terrific effort that was made, but not enough to be successful. So now I'm here to tell you, though, that the decision that came out from Sessions is really a lot of nothing, frankly. I mean, I'll just be blunt about it. He purports to make some changes, and I'll point out a couple of what those things are, but I think that, it's like very self-serving towards whatever his agenda is, which is essentially to try to minimize and reduce the potential for social groups that would be cognizable, right? And to therefore limit people who could get asylum. And it really has hurt people, particularly people with domestic violence related claims and potentially gang claims. So it sounds like what he was doing was very frivolous, but it had horrible real life impact on people. And the question is, how long is it going to take to play out until circuits finally say, kind of debunk the fact that nothing really has changed, or not very much has changed at all. So that's what I'm going to spend the rest of the time talking about, and then we can, have a discussion and have questions about all of this. I mean, you have to see this in context to a certain extent. This is like the campaign that I referred to earlier when I spoke this morning. This is the campaign to undermine refugee and immigrants' rights that's being, fought and we're under attack from this administration and those people outside the administration who want to limit not just, quote, illegal immigration, but legal immigration. And so, you know, this is like the tip of the iceberg, so to speak. But the fact is that it really doesn't change that much for our asylum cases. Some immigration judges who are sitting do not recognize this. And they are those who agree more with the perspective of Judge Couch and his cronies, or Sessions and his cronies, are using this as a way to say, let's pre-termit all these particular social group claims based on DV, domestic violence especially, and also on in gang cases. The theory being that, you know, the way they asserted it is that, you know, these are private actors, these aren't governments, and so therefore you can't really require the United States to grant protection to individuals who would be harmed or have been harmed by these entities. And that is just so much, excuse me, BS, because it says very clearly, and we're dealing here with a statute, which, as we know, if the language is plain, it governs, right? That's Chevron, what I talked about earlier. And our statute says that the person is unwilling or unable to return to their country of origin or residence because of one of the 5 grounds. And so the issue here is whether or not is this country, it doesn't matter what the harm is really, as long as it's serious and severe enough. What matters is, can the government control it? And the way I like to explain this is what asylum really is. If you think about it this way, I think it makes it so clear. What we pledged to do when we signed the protocol in 1967, which incorporated by reference the United Nations Convention on Refugees, what we pledged to do was to provide surrogate protection to somebody whose country was unable to give them the protection that that country owed its citizens and residents. Okay? That's what asylum is really all about. It's a bunch of civilized countries after World War II who got together, and then there have been countries that have joined since, but who got together and said, we believe that everybody should have, whatever you want to call it, a right to live in freedom, a right to live in peace, a right not to be persecuted. And if you can't find that in your own country, and we're a signatory to this treaty, that we will provide it for you. That's the surrogate protection. So in the case of particular social group, unlike religion, nationality, political opinion or opinion, and race, the particular social group ground is one that has its own definition, which we touched on a little bit earlier, right? And the board has kind of done a lot of contortions and acrobatics trying to define it. Is it like ocular visibility, or is it just like you know it's a group because you're aware of it in society, or there's some official statements that identify it as a group in society, et cetera, et cetera. So particular social group is the language, and if somebody now under WYC and HOB can identify the group, putting aside our objections to that formulation and procedure, if somebody can identify the group and show that they're a member of the group and show that it's because of their membership that the persecutor is after them, that's enough for asylum. It doesn't matter that it's a private actor. In fact, it often is a private actor, because if it was only government persecution that we had signed a treaty to protect people from, the treaty would be worded in a completely different way, and the way it was put into our domestic law would be worded in a completely different way. So it's just such a bogus effort that Sessions is making to try to limit the language, the express language that we've enacted in our domestic law. And the reason, by the way, that it's in our domestic, one sec, the reason why that it's in our domestic law is because some treaties are non-self-executing, other treaties are executing, like if we sign off on a treaty, and I guess Congress has to sign off on a treaty, right? One of the houses of Congress at least, then if it's self-executing, it means it goes into effect and it imposes an obligation immediately. If it's non-self-executing, it means that the Parliament or the Congress or the body of law that legislates in the country has to provide some domestic phraseology and rules and so on, which is what happened for the United States with the Refugee Act of 1980. Yeah.
I'm very new to immigration law, but I have learned that there is a difference between whether it's a state actor or a private actor, and you're saying that that distinction should not be there. Where did that's what I thought I heard it wrong.
Yeah.
Where did the private actor versus public actor come into the authority then?
Well, I
Is
didn't.
it case law? Is it
I didn't exactly say there shouldn't be a distinction.
No, I misunderstood.
Okay, no, but I didn't say that, I didn't say specifically that there shouldn't be a distinction. There is a difference between whether it's the government or whether it's a private entity or a private actor. All I'm saying is the ultimate protection isn't different. In other words, if you look at the definition of refugee, it basically here's the language. The language is precisely that the person is unwilling or unable to return to the country where the government is unwilling or unable to protect that person's freedoms and rights or keep that person from being persecuted. So the statute it's section 48A of 101A, it's 101A 48A of the Immigration Act. What? 42, okay, right, 42A. And basically that's, if you look at it right now, that's what the language says. And so it's right there, it's the mandate. And it doesn't say may offer protection, we have to give, asylum itself is discretionary at the end of the day, but when we're looking at whether it's a state actor or whether it's a government actor, if you examine the words unwilling or unable, either the government is, they would like to protect all their citizens or the people within their boundaries, but they can't do it because they don't have it together, they don't have the capacity, or that would be like unable, right? Like maybe they're trying, but they can't really pull it off, or unwilling. And that might be, if the government is the persecutor, they might have animus for the victim, right? So then they wouldn't want to protect them. But maybe they want to, it doesn't matter what they want or not. And so what Sessions did in AB, what appears to be a change, which is really, I think, an ultra-virus overstatement, is he basically said, he changed the, the statement regarding the will of the government to say that the government would have to actively condone the persecution. Like if they were unable to protect anybody and everybody was getting slaughtered, but they really had a good heart and we wish we could, but we disbanded our military last year, so sorry guys. According to Sessions, the government wouldn't be condoning persecution. So according to that definition, he would try to change where somebody like Ms. A.B. could turn for help in her country, and would find that no, we don't have to give her protection, because they really meant to protect her, they just couldn't pull it off, right? So that's kind of what the difference is. And I think the other language that he uses is completely helpless, right? That's complete helplessness, right? For unable or unwilling. So now here's something really important, another point that sort of underscores our position and opposes Sessions' position in matter of AB. There is a standard in the CAT, Convention Against Torture, protection, and it talks about a government that isn't intentionally or officially torturing people. It talks more in terms of a lesser standard, which is more of a like acquiescence or a standard that's sort of lighter than something intentionally meaning to torture and harm somebody. He took a standard like that and inserted it into the asylum language in the statute, essentially, right? So, okay, so that's one of the things that AB purports to change, which you can definitely argue against that, and I'm going to tell you what some of those arguments might be. Okay, so the other thing, he attempts to undermine several other arguments. Like he tries to differentiate whether or not the abuser or the persecutor has a personal relationship with the victim. So in other words, he's trying to say, really the age-old statement that's been made about domestic violence, that it's really a family matter, right? It's not a matter for public authorities to stick their noses into. So he's kind of suggesting that, you know, if a woman comes and her husband's abusing her, and she tries to say she's part of a group and she couldn't leave and so on, such as the ARCG definition had, then he would negate that kind of a claim on the basis that that was just an internal personal matter between these two people, that they didn't get along or whatever, okay? So that was his other effort. I think that none of these are at all authoritative. He was unable to show any authority to really support any of this. I mean, there was some minor case that he quoted as to one of these factors, but basically, if you look at the statute and you look at the actual requirement that each case on its own has to be considered independently on its own facts and the factors present in each case, it's impossible to make a across-the-board statement such as the one that Sessions is attempting to make in AB. And the vast majority of that decision is pure dicta. I mean, it's really not, it's not effectively taking on any of the issues, and he ends up conceding a lot of the issues that, if you read the publicity, it looked like, wow, there were going to be some big changes. And a lot of immigration judges, I think, have kind of bought that. And it serves their trying to, wouldn't it be nice to be able to say like, oh, it's DV? Okay, you lose. End of the day, I'll move on to my next, I'm at 698, only 2 more cases to go to get my 700 quota. I mean, that's what the effort is. You just simply cannot decide an asylum case on a sort of standard like that. If you look back to INS versus Cardozo-Fonseca, which was the case that the Supreme Court differentiated the standard for asylum of well-founded fear versus the standard for withholding of, it was then withholding of deportation of more likely than not as being 2 different standards. The court says very clearly, this is an individual case-by-case determination, and it remains a case-by-case determination. So that's one of the first things that you need to call upon when you're presenting your case to the immigration judge, that each case has to be considered independently, and each of these factors that are present in the asylum statute as elements, that it's the burden of the, for the most part, it's the burden of the applicant to prove, has to be looked at for its own individual factors according to the language in the statute. Now, in AB, Sessions says that there are 3 factors that you have to consider in adjudicating a case: the severity of the harm, the nexus to the ground that's being claimed, and the government's inability to protect. And that's where this concept of the government condoning or being completely helpless to stop the harm from being perpetrated. And the other thing that he does in, the other principal thing that he does in AB is to completely reject and overrule and vacate matter of ARCG, which was the case that stood for the fact that domestic violence, having to leave domestic violence in a situation where the abuser refused to let the victim leave the situation could be a particular social group. And the reason that he gives, and there's some truth to it in a way, in a sort of distorted way, the reason that he gives for overruling ARCG is that in that case, the DHS had actually agreed and conceded that the respondent was the victim of persecution and had been the subject of past persecution. And so there wasn't a real stark discussion or examination of each and every aspect of the case because there was no, it wasn't a contested matter. DHS basically agreed that that was that you could have a social group based on that, and that's true. That was true in ACRG, but so it doesn't mean that the outcome of that case was wrong, as he claims. It just means that yeah, he's right. There wasn't an in-depth discussion of the different aspects of what a domestic violence social group requires. Okay, so now let's just go back in our minds for a second and say, according to the statute, because I keep harping on the statute, right? What's the language in the statute? Okay, so in the statute you have the grounds, the 5 grounds. You have the nexus element, which it depending on whether you're looking at the actual refugee convention or our domestic statute, either says something like by reason of, or on account of, or because of, and that's the nexus. That's showing that the person was in a certain grouping, and because of that presence situated in that, being situated in that grouping, the persecutor was motivated to persecute. And that's what nexus is. We used to always call it on account of, right? But now nexus is the way it's referred to. My recommendation really is that whatever your ground is that you're going to use, ground or grounds, that you start with nexus and look back. It's really not worth it. I mean, you could have a really nice social group, but if there is no nexus, you don't really have a case. So when you kind of have to do some layered thinking when you're thinking about if you're going to use social group or even political opinion. When you're thinking about it, your mind should be thinking the fact patterns that you have, what your client has told you, what you know from the country conditions documents that you've looked at, or from what you've learned from an expert witness's testimony. Does that all come together and show and point at why was this person harmed or threatened with harm, right? Okay, it was because of, and even think about it, explain it to your spouse or your child. Seriously, when you're preparing a case like this, you should be able to say very simply, okay, why were they after this person? Or why couldn't she leave? Or, why was the perpetrator or the persecutor targeting this individual person or a class or a group of people that this person fits into? And one of my favorite cases, which was not touched by AB, but which still is in force, is a case called Matter of Mogherabi. And in Matter of Mogherabi, there's a very simple 4-pronged test. Matter of Mogherabi is at 19 INN 437. I think it was decided in '89. It was shortly after the Cardozo-Fonseca case in the Supreme Court. But here's what it says. Here's the 4 parts. The applicant has a quality or a characteristic that the persecutor doesn't like, or some versions are, or wants to quash. So one, the person has a characteristic. Two, and after Cardozo-Fonseca, it was changed slightly and it became two, the persecutor could find out about the asylum applicant having that quality, right? They don't have to know about it, but they could find out about it. Three, the persecutor has the inclination to persecute that person. Like, they could know about it, but not be motivated to do anything, and then we would have nothing. And four, they have the capability, right? So if you're the persecutor, and you're like fantasizing in your head, gee, I'd like to wipe out all redheads in my country, right? Well, that's nice. You may be able to identify the quality. You may be able to identify who's a redhead, and you may have the inclination to persecute them, but if you don't control the army or the police force or a guerrilla gang or whatever, you're not going to be able to do it. So you wouldn't have the capability of doing it. You've got to have all four of those present. And I put that in every brief that I write. And I think it's really simple and straightforward. And so I really highly recommend that to you. Look, read the whole case, but essentially, that's the most important thing out of the case, in my opinion. Some of the things that the Center for Gender and Refugee Studies have suggested in response to AB, I want to share with you some of those things and leave enough time so we can have some questions. I want to just tell you one more thing. Mogarabi, I gave you the site 19 INN 437 in the late 80s. There's another more recent case from 2011, which is called Matter of N as in Nancy, M as in Mary, and that's at 25 INN decision 526. And it basically stands for the fact that there must be some evidence that the persecutor was motivated by the particular trait or characteristic, right? What?
The page number for Lory is 439.
439, okay. What did I say, 437? Okay, 439. Thank you. Okay, so there's been another case that seems to say the same thing. I didn't have a chance to pull up that case and read it all through, and I can't recall if it cites Mogarabi, but I would imagine it would. I want to give you some of the advocacy tips that CGRS, the Center for Gender and Refugee Studies, have suggested. First of all, they advocate really continuing to push on domestic violence cases. Don't get cowed by an immigration judge into giving it up. Don't go in and say, well, okay, Your Honor, we're going to withdraw and just take voluntary departure. You have a right to make your case. That judge has a duty to consider the individual facts and circumstances of that case. If the judge doesn't or tries to pretermit your presentation and you're putting in all of the evidence, it's your burden. You have to be allowed to put in the evidence to meet your burden. Do as we were talking about earlier, right? Be prepared to go to the board. Be prepared to go to the Circuit Court of Appeals. I mean, my goodness, if you were not even allowed to present your claim, we're not talking about a frivolous claim here, right? So that's a very serious problem if that happens to you. Also, if you're concerned about some crazy judge in your area, because a lot of times this happens, and I don't mean to suggest, to demean in any way any particular judge. I had my own proclivities when I was at the board, and I'm sure many judges do, but if something's going on with your judge that you don't think is kosher or right, then bring it up. Talk to your colleagues about it. Find out if other people have experienced the same thing. If necessary, and this has happened recently, if you're in front of a judge who says, well, all right, we'll go through all your evidence, but this is a loser anyway, I can tell you that. Judges have said things like that, really. if that happens, that is a motion to recuse, waiting for you to write it. Yeah,
Can I
Sure.
just ask you, so on
Yeah.
page, along the lines of CGRS's advice, would you counsel people to point out the language in AB on page 320 that says, while I do not decide that violence inflicted by non-governmental actors may never serve as the basis, so by making that concession up front, it's clear that the Attorney General is not deciding that those cases should be pre-permitted. In fact, there must be cases where it should be granted.
exactly right. That's right. Yeah. I mean, the whole thing, you're right. It's just, this whole decision is so much dicta and so gratuitous, actually, really. But yes, that's correct. You should cite back to him or whomever fills that role that AB doesn't even go as far as many wished it would go, and the Attorney General did not write a decision that absolutely forecloses relief. So that's a really good point. You know, the other, I want to give you some ideas that have been floating around that I think we should be able to move forward on. One is, okay, what are potential social groups? One is, why can't gender women of X country be a social group? It's clearly socially distinct, right? It's particular, and the fact that it has a large number of people in it potentially is not a reason for negating it. I mean, look at race and religion and nationality as the other grounds among the 5 grounds for asylum. That's going to be equally as huge if we're looking only at numbers. So you can't say, well, it's amorphous because there are too many women or female gendered people that would be in this group. What you can do is you can try putting in women in X country, like women in Guatemala or women in El Salvador, and you can propose it alone or with another factor that can slightly modify it, which would actually narrow it down a little. I'm not saying go in there and just try to blow the cord away by saying, too bad, I'm just going to say all women qualify here. You know, you basically want to win for your client. So you want to make the judge comfortable that he or she is not going out on a limb. And if you can get them to the point where you win without doing that, by all means do it. So if you can put in a relationship, a particular relationship that would modify and narrow the group, age, all the other grounds, race, religion, nationality, beliefs, a shared past experience. Remember, such as, what was it, policeman, former policeman or something, does that matter? Fuentes, right? Right, yeah.
And also Acosta.
And Acosta, taxi drivers or whatever. Well, they denied that case, actually. But, anyway, so you get the picture. If there's some way you can modify and kind of narrow it down the funnel a little bit, then okay, that's fine, do that. But the point is that when we're talking about gender specifically, is that we can, there have been courts, and I'm really sorry, I apologize that I don't have them right in front of me, maybe you know, but there are courts that have recently commented. There's at least one Circuit Court of Appeals that made some comment about like that gender would make sense. And indeed, in Acosta, didn't they say sex was one of the grounds? That would be an immutable characteristic. So we talked a little bit about the unwilling or unable. Again, this is something that is really fact intensive, right? And so each case is going to be different. And my advice is, as I said, distinguish the language in the statute of unable or unwilling to distinguish that from the CAT standard, which is different. Distinguish it from the complete helplessness standard that Sessions is proposing. And then also address, here's something interesting, that when you're arguing that the police failure to respond constitutes evidence of the government being unable or unwilling to protect your client, their failure to respond does not have to be on account of the same reason as your nexus. In other words, if you're arguing family or DV, the unwillingness of the country officials to respond and protect their citizen doesn't have to be on the ground that you're raising, right? They can do it because they're lazy, because they're corrupt, because they're infiltrated by the gangs, or whatever other reason, and you can still have a DV claim. So just keep that in mind. You don't have to show a nexus when you're showing the unwilling or unable factor. The other thing to be aware of, just in each of these instances for each element, be aware that no matter what is said in AB, you don't want to concede really any change from where we are. For example, the AG comments in AB on what would be reasonable with respect to internal relocation, okay? Now the statute or the regs actually say you have to consider a lot of things, other serious harm, there are other factors, and you have to comply with the regulations on relocation, and there's some burden shifting that goes on. So make sure that you can't just kind of cut to, this is reasonable, this isn't reasonable, because that's what the AG says in matter of AB. And then the final thing actually in the actual Sessions decision in AB is credibility, right? Because isn't it interesting how it used to be that everything turned on credibility, and now we've suddenly been focused on something different and substantive in a different way. And so one of the things CGRS recommends is that once again, when we're talking about particular social group, we're talking a lot about fact-intensive analysis, and however, keeping in mind the clear error standard for factual findings made by IJs versus de novo findings for legal questions or mixed questions of fact and law. PSG can be identified as a mixed question of fact and law, because we're talking about the specific aspects or elements of it together with the individual facts from your client's case. So why don't I
We'll leave
stop?
time for questions?
I was just
Yeah.
gonna say, let's
Yeah.
take some questions.
Okay. We have about 10 minutes for questions. Mr. Modi?
Thank you, Honorable Judge Rosenberg. I really appreciate it. Quick,
It's fine to call me Lory.
all right, Lory.
We're friends here.
So, quick question. In terms of overturning matter of AB and circuit courts looking at this issue, do we know which dockets, are looking at the issue, an estimated timeline of when we may get decisions in which circuit courts?
I don't know the answer to that. Does anybody else? I have some thoughts about it. I think that there's, we know, for example, there was an unpublished decision out of the Fourth Circuit, another North Carolina Charlotte IJ case that we also filed an amicus brief in, and it went back to the board on a motion to reopen and reconsider a Judge Couch, one of those kind of horrible, weird decisions. So that eventually either AB or this one, which is called MF, I think, or something like that, are going to end up going to the Fourth Circuit.
Yeah. I think that AB is not pending in the circuit right now.
No, it's
AB was remanded,
Yeah.
correct?
Yes.
So that's the problem. It's the actual case AB is not at a procedural posture that it could be appealed right now.
Right. And
That's the
neither-
problem.
Right, and neither is,
Yeah. Yeah. I think CGRS is tracking those.
Yeah.
CGRS.
I
So we
I
could,
don't know.
so I would contact CGRS, which is at Hastings University.
Or they, maybe
Hastings.
on their website, they may
Yeah.
have it listed
Yeah.
there.
Other questions? Oh, yes. Oh, we're taping it. Oh, that's why. We have to have the mic.
Your
Does an attorney lose credibility with IJs if we don't acknowledge the authority that AB currently has? And if not, how can we maintain a posture, especially, for instance, in motion practice, where we acknowledge the authority of AB as the empirical reality, but also maintain a stance of fighting for our client as if AB did not have the power that it currently sees?
Okay, so that's a really good question. But look, first you have to convince yourself that AB didn't really overturn or change anything. All it really did is overturn and invalidate ACRG or ARCG, whichever it is, and so you can't cite that as authority. That you cannot do, and I'm not suggesting that anybody do that. I think you can comply with AB and that you have a responsibility to comply with it, and in complying with it, you have to educate the court that, in fact, there really, for example, as Jeff pointed out just a couple minutes ago, when he said that the Attorney General didn't really say dispositively that no case could qualify or something like that, right? I can't remember now what we were talking about that, but so the fact is, if you really look at the decision, if you look at the difference between what the decision really says and what Sessions has been quoted about saying, or even what Sessions, I think, said when he spoke to the IJ conference several months ago, they're completely different things. We're responsible, and the board is responsible for looking at the actual case. So you can take that case apart. That's all I'm saying. Everything that I've said here are not just arguments to try to win something back. There are ways that you can dissemble AB and say, we're following AB. Here's what AB instructs on X element. Here's what it instructs on Y element, and so on. As a matter of fact, I think that would be a good way to do it, because you'd be pointing out for the IJ, like, let's take this on page X. We're discussing this aspect. Here's what the case permits or allows or holds or concludes, and go through it like that.
What I was saying too is that the decision really leaves open the door. It leaves open the door wide open if you read it really carefully. Because what it says is that the Attorney General is saying, I'm not saying it can never happen, but what he's saying is I really don't want it to happen. And so
There will be a minimal number of cases.
or I'd like to limit it, is what if you read between the lines. But then I think what he's saying is you need a really fact-specific approach, and that goes back to your point about why he vacated ARCG. So again, to answer Kate's point, you have to make a really, really good record. I think Susha Modi made that same point. We have to make a really, really, really extensive documentation about country conditions, psychological harm, nexus. And again, if you do all that, I don't think AB would necessarily preclude granting a domestic violence case.
Right, and the other thing is, you can make arguments for domestic violence survivors using political opinion or imputed political opinion, like I said earlier. So what we're fighting against is the encouragement from the Attorney General's office and the tendency to want to grab onto that recommendation of writing a hard and fast rule. No DV case can win. No, that's not true. Even if we don't do it under PSG, we can do it as an imputed political opinion. Sorry, you got to hold the hearing.
Any other thoughts or questions? Okay, well, yes, sorry, Judge Rose.
Have you seen that Homeland Security is moving to pre-dermit?
No, judges are independently sua sponte doing it.
Oh. ridiculous if they don't move to do it. If I was the Homeland Security lawyer, I'd be really worried about my record if things get decided quickly. And I've litigated with in federal courts for Homeland Security or INS for many years, and I've seen litigators say, "No way we can defend this thing." The other thing I want to tell you is that if you think that there's a precedent, you try to distinguish it, and if you don't, you say, "Look, I believe that this is wrongly decided," and that the reviewing court is going to find that
Yes.
it is. So therefore, I want to make a record. No judge sitting in a thing will be mad at you for doing it.
Yes, that's a really good point. And in fact, it's your ethical
Right.
responsibility to do so.
Right. Okay. So let's have a big